We're back on the air, and this is Radio Entrepreneurs, and we are always featuring the best of entrepreneurship. And all week long, all these new segments are being featured by the court reporting company of O'Brien Levine, and they're also our hosts for the week. And we're very glad to be here. So obviously, since we're doing our On the Record show, we're talking to attorneys and litigators all week long, and my co-host here to back me up is Mark Z from Mark Z Legal Staffing. I blanked out there for a second.
Can't forget me. Great to be with you, Jeff. This is a lot of fun. I feel like we're in the playoffs.
And we are. This is great, and we want to thank O'Brien Levine's great. They put together a great lineup for us. Our next guest, a newcomer to Radio Entrepreneurs, so he doesn't know what he's in for. Stephen Reingold of Jager Smith. Welcome.
Good morning. Thank you.
Stephen, you want to tell us a little bit about your practice?
Yes, thank you. Thanks for having me. So I am a commercial litigator. So my practice is comprised of dealing with complex commercial litigation matters, bankruptcy litigation matters, employment discrimination and employment termination matters. There's a bit of an overlap, is what I would like to tell people when I talk about my practice. I deal with commercial disputes, but there are often in several areas of law which most litigators do handle. So it could be anything from a breach of contract claim to a breach of fiduciary duty claim to a wrongful termination claim, anything of a commercial dispute, either for businesses or business owners, is something that I would handle. I also do, as part of that, and I thought maybe an important takeaway for your listeners is a lot of what I do as a litigator is also prevention, risk avoidance, risk management, because not every dispute should end up in litigation or arbitration or mediation, and oftentimes it's helpful to bring in a litigator early,
Right.
because what I do a lot of is advisory work as well.
Right, you're a rarity in the legal community because a lot of litigators, they immediately get the work. The first thing they're thinking about going to litigation, preparing all types of pleadings, running up the clock, and entrepreneurs really are litigation adverse. And if they have somebody working with them to say, not only, okay, if we get to that stage, I'm a strong person to go into court and advocate for you, but what's great is you're an advisor to these entrepreneurs that have a limited budget or they have a budget, but they don't want to eat the whole budget up. And this way, pay me now, pay me later, it sounds like you have some very good tips that could be helpful.
Well, absolutely. I recognize that lawyers are, a line item on the expense side, no question about it. And people are cost sensitive about legal fees, but there are times when it does make sense to bring someone in early because you can avoid spending more later if you identify an issue and address it up front. I can give you one example if you would like.
Absolutely.
So I had a client here in Massachusetts of a manufacturing concern negotiating a sales agreement with a company in California. My client had all the leverage. This California company very much wanted to do business with my client. But in doing the sales agreement, the client did not focus on the dispute resolution provisions in the agreement. Signed the agreement, started the relationship. When the relationship went sour, I get a copy of the agreement. Come to find out that the dispute resolution provisions provide for mandatory arbitration in California, governed by California law. So the president of the company and I had to spend 2 days in California at an arbitration proceeding. My point in raising that is if the client had spent just a little bit of time with me before signing the contract, that's an issue I would have identified and said, you have the leverage here.
Right.
This is not something you should agree to.
Right.
At the very least, we should try to negotiate this out.
And have it in
Have
Massachusetts.
it in Massachusetts, governed by Massachusetts law. If the buyer wanted to do business with you that badly, they would have agreed to that. Or at the very least, we could have removed it entirely, in which case there might have been a fight down the road as to jurisdiction, but not give up that point from day one.